This video was created with AI to support SQE1 study. We are independent and have no affiliation with the SRA, Kaplan, or the SQE. We do not share exam content, and our videos are for informational purposes only and should not be used as legal advice. Please check and refer to primary legal sources and recommended prep guides as you study.
Hey everyone, welcome. If you're prepping for the SQE1, today we're going to crack the code on one of the toughest parts, exemption clauses. Nailing these is a huge deal, and I'm going to show you exactly how to do it. First, we'll cover what these clauses even are. Then we'll jump through what I call the three hurdles: incorporation, construction, and statutory controls. Finally, we'll put it all together into a framework you can take right into the exam with you. Okay, let's dive right in. First up, what exactly are we dealing with here? We got to know what an exemption clause is before we can start picking it apart. So, in plain English, it's a clause where one side basically says, hey, if something goes wrong, I'm either not responsible at all, or I'm only on the hook for a certain amount. It's really just a way for parties in a contract to decide who carries the risk.
And it's really important to note there are two main flavors of these. You've got exclusion clauses, which try to completely wipe out liability. Then you have limitation clauses, which just cap the damages. And this distinction is super important because, as you can imagine, the courts are way more skeptical of a clause that says, we're not responsible for anything at all.
This brings us to our framework. For an exemption clause to actually work, to be enforceable, it has to clear three hurdles. And I mean every single one. If it stumbles on just one, it's out. So think of this as your essential checklist for the exam. All right, let's tackle hurdle number one, incorporation. The question here is super basic but absolutely critical. Was this clause even part of the contract to begin with? Because if it wasn't, well, game over. We don't even need to look at the other hurdles.
So, how does a clause get into a contract? Well, there are three main ways. First, by signature. You signed on the dotted line. Second, by reasonable notice. They made you aware of it. And third, by a course of dealing. You've done business this way a bunch of times before.
Okay, so the big one is signature. And the rule here comes from a really famous case, Lestrange v. Graucob. The rule is pretty harsh, actually. If you sign it, you're bound by it. Doesn't matter if you read the fine print or not. The law sees your signature as you saying, yep, I agree to all of this.
But, and this is a big but, there are exceptions. The rule doesn't apply if someone lied to you about what you were signing. Take the Curtis case. A woman takes her wedding dress to the dry cleaners. They ask her to sign something and tell her it just means they're not liable for damage to the sequins. But actually, the clause excluded liability for any damage. When the dress came back stained, the court said, nope, you can't rely on that clause because you misrepresented what it meant. See? Makes sense? Okay, so what if there's no signature? Then it all comes down to reasonable notice. And there are a few rules here. The timing has to be right. You have to be told before or at the time you make the contract. Like in Ollie v. Marlborough Court, a notice in the hotel room was too late because the contract was made at the front desk. Also, the clause needs to be in a document that looks like a contract. In Chapleton v. Berry, a ticket for a deck chair was seen as just a receipt, not a contract, so the clause on the back didn't count.
And this leads to one of my favorite ideas in contract law, the red hand rule. This comes from the legendary Lord Denning, who basically said that for a really harsh or unusual clause, you can't just bury it in the fine print. No, you need to print it in red ink with a giant red hand pointing right at it before a court would say you gave enough notice. It's a great visual, right?
Okay, hurdle one is cleared. The clause is officially in the contract. But that's not the end of the story. Now we hit hurdle two, construction. This is all about the wording. Does the clause actually say what the party thinks it says? Does it cover the specific thing that went wrong? And the main rule here has a fancy Latin name, the Contra Proferentum rule. Don't worry about the Latin. All it means is that if a clause is ambiguous or unclear, the courts will interpret it against the person who tried to put it in the contract. So if you write a vague clause, it's going to be your problem, not the other person's.
Now this gets really important when we're talking about excluding liability for negligence, for carelessness. The courts are super strict on this. If you want to get out of being liable for your own negligence, you have to be incredibly clear about it. The best way? Literally use the word negligence. If you use some broad phrase like any loss, the court will probably say that only covers things like a breach of contract, not your own negligence.
All right, so imagine this. The clause was incorporated properly, and the wording is perfect. It covers exactly what happened. We're home free, right? Nope. There is one more massive hurdle to clear. Hurdle 3, Statutory Controls. This is where Parliament steps in and says, even if you agreed to it, we might not let you enforce it.
And for your SQE exam, you need to know which law applies. It's pretty simple. Is it a business dealing with another business? That's the Unfair Contract Terms Act 1977, or UCTA. Is it a business dealing with a regular person, a consumer? That's the Consumer Rights Act 2015. For today, we're going to focus on UCTA because it comes up all the time in those B2B scenarios.
Now listen up, because this is a big one. There's one rule that is completely non-negotiable. You can never, ever exclude or limit your liability for death or personal injury caused by your negligence. Period. It doesn't matter what the contract says. Any clause that tries to do this is automatically worthless, just completely void.
Okay, so what about other kinds of loss, like financial damage or damage to property? Well, for those, the clause isn't automatically out. Instead, UCTA says it has to be reasonable. And the court will look at a bunch of things to decide what's reasonable. A huge one is the bargaining power of the parties. You know, was it a fair fight between two giant corporations, or was it a massive company forcing its terms on a little startup? That kind of thing really matters.
Right, we've gone through all the theory, we've jumped the hurdles. So now, let's put it all together. How do you actually use this to answer an SQE question? Let's build the perfect framework.
Every time you see a problem question on this, just walk through these steps. 1. Identify the clause. 2. Hurdle 1. Was it incorporated? 3. Hurdle 2. Does the wording actually cover what happened? 4. Hurdle 3. What does the statute say? And finally, 5. Conclude. Pull it all together and decide if the clause is likely to stand. If you follow this every time, you'll be golden.
Okay, let's wrap up with a little challenge for you. You've got a software firm in a B2B contract. They've got a clause limiting their liability for data loss from their own negligence to just £1,000. Their client, a small bakery, loses 20 grand in online orders when the server crashes. Now, run that scenario through our framework. Go through the 3 hurdles. Pay really close attention to that UCTA reasonableness test. Is that clause going to hold up in court? Thinking through problems just like this is exactly what's going to get you ready for the exam.